process looks like for students in disciplinary hearings. So in 1975, can everyone hear me? So in 1975, the Supreme Court decided Goss v. Lopez. And in that case, there was a student who was suspended from a public high school in Ohio. Allegedly, there was some kind of disruption in the school cafeteria, and there was property damage, and a bunch of students were suspended. This one student, Lopez in particular, said that he wasn't taking part in the destruction of property, but he was suspended before he could give his side of the story. So he and his parents sued the school system, saying they were deprived of their due process rights by being suspended without giving his side of the story. The Supreme Court said that the student was right, that the school did violate the student's due process rights. And in deciding that, the Supreme Court said that at a minimum, public school students facing suspension must be given some kind of notice and an opportunity to be heard. And so they define notice as being told what the student is accused of doing and what the basis of the accusation is, and hearing as an opportunity to explain the student's version of the facts in the discussion. Now, there were some limitations on Goss v. Lopez, that Supreme Court decision. So the first limitation is that holding only applied to public schools and public institutions. So private schools, private universities were not subject to that holding, and therefore could come up with any process they wanted or have no process at all. Another limitation of that holding is that there were no parameters for the timing and the content of that notice. And in fact, the Supreme Court said in their decision that in a majority of cases, the person who's dealing with the discipline can informally discuss the alleged misconduct of the student minutes after it has occurred. So there doesn't have to be this week or a month or long period between when notice is given and when a hearing is held. The decision also did not set out what the parameters or the nature of the hearing needs to be. And in fact, they said that we stopped short of saying that the due process clause of the Constitution requires that hearings in connection with suspensions include the opportunity to secure counsel or to confront and cross-examine witnesses to support the charge, or to call his own witnesses to verify the version of the incident. And finally, the decision did not recommend any kind of evidentiary standard that has to be used in these disciplinary processes. So as you can see, the U.S. Constitution sets a very low baseline for what due process protections are for students who are subject to disciplinary sanctions. So basically just notice and an opportunity to be heard. It can be very informal, and schools can still go ahead and discipline after those things are given out. But luckily, Title IX provides additional processes for students, both survivors and the accused, in sexual assault proceedings, but also in other proceedings related to disciplinary issues under Title IX. And so what are some of these procedural rights? Well, first of all, I want to say that Title IX applies to all schools that get federal funding. So it doesn't just apply to public schools. It also applies to private schools that get federal financial assistance, and for-profit schools that also get federal financial assistance as well. And Title IX requires schools to have a non-discrimination policy, but it also requires schools to adopt grievance procedures to respond to sexual assault complaints. So each school's grievance procedure must have a notice of the things that students would be subject to being disciplined for. It must have provisions for an adequate, reliable, and impartial investigation of the complaint, which includes the opportunity for both the complainant, so that would be the survivor, and the respondent, which would be the accused, to present witnesses and evidence. The school must also give a reasonable and prompt time frame for the major stages of the complaint process. And there must also be written notice to both the complainant and the respondent about the outcome of the complaint. And there must be assurances that the school will take steps to prevent the reoccurrence of sexual violence. And also there must be notice about potential remedies for respondents and potential sanctions for the or remedies for the complainant and sanctions for the respondent. And so in 2011 and also in 2014, the Department of Education put out guidance about what these disciplinary processes can look like. And because the department realizes that no two schools are the same, they don't prescribe a lot of things. Generally, under Title IX, which is a law that was enacted to promote equity in education, what the department says that if you offer to one party one procedural protection, you must also offer that same procedural protection to the other party. So, for example, if one party is allowed to have a lawyer or an advisor, you must also allow the other party to have a lawyer or an advisor. And same things for prohibition. So if the complainant can't have an attorney present, then the respondent can't have one either. Similar things for right to submit expert testimony or the right to appeal a decision. And I also want to add that in addition to Title IX, the Clarity Act also guarantees both respondents and the complainants a right to an advisor of their choice. And both parties have to receive the outcome in writing at the same time. So as you can see, Title IX actually gives a lot more procedural protections to both survivors and the accused, and also maintains the laws focused on equity for both survivors and the accused in disciplinary processes. So one other thing that the Department of Education guidance requires is that in these disciplinary hearings that investigators and the hearing board use what's called the preponderance of the evidence standard. And so what the standard means is whether or not it's more likely than not that misconduct occurred. And basically, it puts both the complainant and the respondent on equal footing. So I want to step back a little bit and kind of talk about the ways that a college administrative proceeding is not like a courtroom or not like a criminal process. So in a criminal process, the standard of evidence is beyond a reasonable doubt. And that's because in a criminal proceeding, the stakes are so much higher, and also the two parties aren't on equal footing. So in a criminal proceeding, you have the government or the state attacking the liberty interest of the defendant. But in a administrative proceeding in a university, you have two students who are on equal footing, and they both have a right to be in that educational setting. And so what the preponderance of the evidence standard does is say, you guys are both on equal footing, and so rather than having a beyond a reasonable doubt, which puts a big burden on the government because there's so much at stake for the defendant, preponderance of the evidence says if one side tips the scale just by 51% or 50.01%, then that side wins. And it's so for a variety of reasons, this is the correct standard to use. So this is the standard that's used in civil rights cases like Title VII, which prohibits discrimination in employment, and Title VI of the Civil Rights Act, which prohibits race and national origin discrimination in federally funded programs. It's also the standard used in most civil proceedings where the two parties, in court proceedings where the two parties have an equal interest. And it's also used in civil proceedings that deciding things that arise out of conduct that can be criminal. So, for example, like criminal action or tort actions such as battery, robbery, or even murder and wrongful death. And so I talk about this a lot. So, like, the criminal trial for O.J. Simpson ended in a not guilty verdict because the standard was beyond a reasonable doubt, whereas a civil trial ended in O.J. Simpson having to pay the Goldman family millions of dollars because the standard was preponderance of the evidence. And the preponderance of the evidence standard is particularly appropriate for a claim of sexual assault where survivors are routinely not believed and their credibility is routinely questioned just when they come forward with their story. And so this is the right standard to use, and it's actually used in 80 to 85% of schools. And so that's kind of an overview of what due process protections are afforded to students and how Title IX provides those protections. And with that, I will hand it over to Alexandra, who will take over the presentation.
Before you begin, sorry, just one second. I just wanted to welcome everyone and remind you that we'll be answering questions after all the presentations are over. So after Alexandra will be Dean Anderson, and then we'll be doing a Q&A. So hold your questions. Thank you.
Great. I'm so excited to be talking with you all. I want to apologize in advance. I have a little dog in here and it's about walk time for her, so you might hear some barking. So apologies in advance, but I'm so excited to be talking about this because this is a topic that's really close to my heart as someone who really cares about ending sexual harassment in schools and also really cares about unfair student disciplinary procedures. So I'm going to start off by kind of talking about one of the common myths that we see in media discussions about fair process on college campuses and Title IX. And I hear again and again that this is a zero-sum game, where if we're going to have better protections for survivors on campuses, that is inevitably going to come with unfair disciplinary procedures. And that's just not the case. So I think that probably the best evidence we have of that is that schools punish students for things all the time, right? It's not like Title IX is the only context in which schools take disciplinary action. And that means that we have a model and it's really just about perfecting this now. And one of the reasons that these two interests aren't practically irreconcilable is that survivors and accused students often ask for the same thing. So I spent part of my last year going through complaints and lawsuits from survivors who felt they'd been mistreated by their schools in disciplinary proceedings, and also by accused students who said that they were wrongly suspended or expelled. And often both parties would say, I didn't get an impartial decision maker. I didn't have access to the record on which the decision was going to be made. I didn't have the opportunity to present evidence. And many of these things are, at public universities, but maybe constitutional violations, but certainly violations of the best practices and the guidance that the Department of Education has put out there. So that says to me that what we're fighting for truly is fair procedures for everybody. And as Adaku mentioned, the Office for Civil Rights of the Department of Education has put forth guidance that really tie protections for one party to protections for the other. So by saying that you have to provide the same kind of protections to both sides, the Office for Civil Rights has actually protected accused students each time it increases protections for survivors. And I think that that's good news for everyone. So I want to make, and I also think that at sort of the heart, I think that there are true shared principles between the fight to end gender violence on campus and support survivors and the fight to ensure fair student discipline. And I'm going to go into that in a little bit more detail, but I think that this is, I want to sort of just start off by saying that in both contexts, we are asked to recognize how important the opportunity to learn is. And I think that the more that we can center our work around that shared principle, the more common ground we can build and the more progress we can make. So first, I kind of want to make the case for why we should all care about this. And I want to start with a caveat that I'm making a case for why the movement should care about this, why our campus organizations should care about this. I'm not saying that every survivor or organizer has to take on the burden of advocating for fair procedures. I know that for so many who have been screwed over by our schools and seen wrongdoers face no repercussions, it can be really hard to care about fair process for accused students. And so I want to say that this is something that our movement should care about without putting that burden of empathy on any individual survivor. So again, I think that there are some practical reasons why we should care, and some of these go to the shared interests that I discussed earlier. So many of the protections that survivors want in disciplinary procedures are also desired by accused students. Again, things like impartial decision-making and the opportunity to appeal. It's also true, disturbingly, that a lot of survivors face disciplinary sanctions themselves. So there's been sort of a high-profile case recently about survivors at BYU who have been faced disciplinary sanctions after coming forward about their assaults. And this is something we hear often, also particularly in cases of intimate partner violence, where the abused party in self-protection may have done things that subject them to honor codes. And so we want to make sure that disciplinary procedures are fair for accused students, because sometimes accused students are survivors. And finally, my sort of last practical reason why we really need to care about this is legitimacy. And I mean that both legitimacy for our movement and legitimacy for our campus procedures. I think at the start, we talked a little bit about how sometimes opponents of Title IX will use the perceived unfairness of campus disciplinary procedures as a reason to force police involvement. And that's an absolute disaster for survivors, as was discussed. But I think we need our campus communities and our country to believe in schools' ability to do this right, and to believe that our movement is thinking responsibly about these questions if we're going to get things done. And then again, I want to talk about, in terms of why we should care, some shared principles that for me are really at the heart of this work on both sides. At the center, as I mentioned earlier briefly, is the importance of access to equal education. Suspension isn't prison, which is why we don't have the same kinds of procedural protections that we do in school discipline as we do for a criminal trial, but suspension is still pretty serious. We fight so hard for survivors' ability to continue to learn that we also have to recognize that a suspension is a pretty serious deprivation of an opportunity. It's also true that our movement is motivated by a commitment to anti-discrimination, and we don't have any data yet about the impact of specifically gender violent school disciplinary procedures on different communities. But I think we know just from school discipline at large and from our legal system that inadequate procedural protections leave too much room for discrimination against accused students. And finally, I want to flag that this isn't just about gender violence. My dream, I will be upfront, is for this conversation to give rise to an opportunity to think about fair procedures across all contexts. So not just for gender violence, but students who are accused of selling drugs out of their dorm room, or cheating on a test, or talking, as we see in the K-12 level a lot, talking back to a teacher. And I think that the more that we can recognize, we can situate our conversation about procedure across different substantive violations, the bigger chance we have of uplifting other students in our efforts, and making sure that other students, like students of color, including women of color on the K-12 level, who face terribly high levels of school suspensions and expulsions. I am hoping that this renewed national energy and care about fair process and student discipline won't just be about Title IX, but will help all students. So I just want to talk briefly about kind of goals. How, if we care about these issues, how can we orient ourselves? Sorry, that's Margot barking. And I think that Adaku touched on this, that it's really hard to present sort of uniform policies for all schools, because we know that each campus community is different, has different problems, and also that schools have different kinds of resources. So one push that I've seen is for some schools to provide free legal advice to both sides in any disciplinary hearing. And while I think that that's great, I recognize that not every school has the ability to do that. So I do want to say that there are some good basics in letter that Note 9 put forward, and the organizers can share links. Someone is not muted. If you could do that, that would be great. Yeah. I'm just gonna get that going on there. Yeah, if you're sorry. Okay. If you're not, don't mind muting. We're just trying to figure out how to Great. I'm going to try to keep soldiering through. Apologies if it's a little hard to hear. But I think that some of the things that Know Your Nine mentioned in the letter are the opportunity to appeal a decision within the school, not to a court, but within the school, the opportunity to present evidence, access to the record, and timely notice. So Adaku spoke a little bit earlier about how parties to a student hearing really need time to look at the record and to figure out what their strategy is going to be, and also, again, an impartial decision maker. I think that it's important if you're working on a campus, building inter-movement partnerships to identify common problems faced both by survivors of gender violence making complaints and also students who face interactions for all kinds of problems, not just gender violence, but again, situating this in a broader student discipline conversation. And that leads to sort of my final comment, which is really just, I guess, a piece of framing advice as well as substantive advice, which is that I think that we benefit so much when we expand our focus in student discipline conversations away from gender violence. And part of it is just that there's this common rape exceptionalism where people are, lots of critics are totally comfortable with the preponderance of the evidence when it's used for a student who punches his or her roommate in the face, but think it's totally inappropriate when it comes to gender violence. And I think that that really speaks to the monopoly that the criminal law has on our imaginations about how we can respond to gender violence. But the truth is that schools have this responsibility. They've had it for a long, long time. Civil courts that use the preponderance of the evidence also have responded to gender violence for a long time. So I think that the more that we can talk about student discipline at large and not just student discipline around gender violence, the better off survivors are. And again, I also think that this is just an opportunity for us to improve the state of discipline, the student discipline in our country at large, and not just putting the burden on gender violence, but really uplifting all students. So I'm happy to take questions at the end, and I'm really excited for this opportunity.
Hi, folks. Can you hear me? I hope you can. Maybe one of the presenters. Oh, Alexandra can hear me. That's great. So I'm Michelle Anderson, and I'm excited to be here. I apologize for two things. My camera doesn't work, or at least I can't figure it out. And number two, I don't have a puppy dog. So these are sad truths, but you will have to listen to my voice, and we will hope for the best. So what I want to talk about today is actually about sanctions for findings of responsibility for sexual assault on campus. And we have a history of campuses, colleges and universities not taking campus sexual assault seriously and engaging in these slap on the wrist sanctions where, you're someone who's found responsible for sexual harassment or sexual assault on campus, but you have to write a reflective essay and send that essay on why what you did was wrong. And I think there's or you're going to be one semester suspended with an automatic readmission or any number of other things that many of you on this phone call recognize as endemic to how many campuses respond to sexual assault, if at all, and also just symptomatic of a larger problem of not caring about the concerns that victims have in terms of the campus taking the wrongs against them seriously. So what I want to talk about actually is why it's not a good idea, why I don't think it's a good idea for students and others to push for mandatory minimum sanctions. So this came out most recently when the legislature in California proposed a mandatory minimum expulsion if someone was found responsible for a sexual assault on campus. And Governor Jerry Brown rejected that proposal, and I think Governor Brown was right about that. And the reason I think that mandatory expulsions and other mandatory minimum punishments are a bad idea has to do with an understanding of what has happened in the anti-rape movement and the way that criminal sanctions have changed over the past few decades. So I want to tell you a story about that, and then I want to tell you what I think it portends for our work trying to address campus sexual assault. So at the same time that feminists were actually making progressive moves in the law, the criminal law, to try to address a broader scope of behavior that should constitute rape. At the same time that was happening in the criminal law, there was a conservative movement to impose dramatically increased sentences on findings for guilty verdicts, the finding that someone is a sex offender. And so the lingo around sex offenders and sex offender registries and community notification is actually fairly new. It's happened over the past couple of decades in response primarily to very notorious cases of child rape and murder, kidnapping, rape, and murder. So Megan's laws, a whole series of collateral consequences that have mandatory implications when one is found guilty as a sex offender. Mandatory registration of sex offenders, mandatory community notification, new laws that mandate mandatory minimum sentences, and these sentences have overwhelmingly across the states been much more draconian. A large percentage of the states have made their sentences for rape harsher over the past few years. And this has not been entirely a good thing. It is something that I think is a natural concern. A natural response is to be sympathetic to these kinds of laws when something like the rape and murder, kidnapping, rape, and murder of a child happens. But the problem is that these laws have perverse consequences for rape victims, most of whom were not murdered, were not kidnapped, and did not experience traditional force in the sense that the criminal law has conceptualized it. What they are, what most rape victims are, as many of you activists know, they are victims of acquaintance rape that don't involve extrinsic violence, where a weapon is not present, but the offender uses force, coercion, force in the form of coercion, pinning, ignoring someone's pleas to stop and cries, but not the kind of traditional extreme violence that the criminal law is comfortable recognizing. So these laws, both in terms of the criminal sanctions, the amount of time someone spends in prison, became more draconian, and in terms of the what are called collateral consequences, the civil consequences of a conviction for a sexual offense. Community notification, registration, sometimes zoning laws that prevented offenders from living in certain areas, and a whole range of other things. These passed overwhelmingly, primarily because conservatives got on board and moved the drug war to the war on sex offenders. And kind of the war on crime became the drug war in the 80s, and then moved to the war on extreme sex offenders. So the situation is, you might be surprised to know that the progressive anti-rape movement actually opposed both of these moves. for a couple of reasons. One is that it decreased the likelihood that victims who were acquaintance rape victims could obtain, could have the police take their crime seriously, could have the jury and the prosecutor choose to pursue, and the jury convict, and the judge sentence. When there are draconian consequences, or what are perceived of as draconian consequences, it distorts the processing of these cases all the way back to the reporting. Some people, for instance, don't report when they know that the consequences of a conviction will be so draconian on the tail end. Some police say, hey, this isn't the kind of crime, what you're reporting to me, you acquaintance rape victim, this is not the kind of crime that warrants these draconian sanctions, so I'm not going to pursue it. I'm going to file it I'm going to misfile it, or I'm going to bury the report. The prosecutor chooses not to pursue, the jury chooses not to convict, the judge or the jury chooses not to sentence, depending on how the process works in the individual state. So what I think it's important to note is the perverse effects that mandatory minimums and draconian collateral consequences have had on the way the criminal justice system has viewed the vast majority of victims of rape. That is, those who don't have force used against them in the form of a weapon. They are not kidnapped. They are subjected to the kinds of routine, what I call all-American rape. It involves alcohol, it involves pinning, someone's floating in and out of consciousness, or they're crying and saying no, but the offender proceeds anyway. So here we have a situation that we're working on as activists and others concerned about the way that campuses haven't done bupkis to respond legitimately to findings of responsibility for sexual assault on campus. And when universities do nothing but slap on the wrist, folks say, well, that's totally unfair, and we should push for mandatory minimums. While I understand, like a mandatory minimum of expulsion, while I understand that impulse, I think it's both not strategic for the movement, I think it's not strategic for the victims themselves. And I don't think it aligns with our long-term interests as a progressive movement. I believe that if there is a mandatory, and in fact there's evidence from the history of rape law and its consequences to suggest that if there are mandatory minimum expulsions, mandatory minimum penalties, administrative penalties for a finding of responsibility for sexual assault, there is reason to believe that that will result in fewer people reporting, fewer findings of responsibility. Decision makers, both victims themselves and the decision makers that make these administrative findings in campus proceedings, are influenced by the consequences on the tail end. And when those consequences are perceived to be too draconian to impose upon the friendly fraternity brother, the nice swimmer who has a bright future, etc., those who we might, who are on campus and who are otherwise sympathetic, it's going to actually have the perverse effect of decreasing findings of responsibility and potentially decreasing the folks who choose to report. So that's the history of sanctioning in the anti-rape movement. I think in the anti-rape movement in the criminal law, we should band together and work very hard to get rid of mandatory minimums and to make criminal sentencing much less, and to abolish collateral consequences for a conviction of a sexual offense. What lessons can survivors and feminist activists draw from that history? Well, I think the lessons are that we should not be promoting mandatory sanctions, even if expulsion seems like a fairly minor sanction. In the context of campus discipline, it is the death penalty, okay? I'm not trying to be hyperbolic. It is the most extreme sanction that one can impose, is expulsion from the campus community, a permanent mark on your academic transcripts. These kinds of things are the most extreme forms of sanction. And when the most extreme forms of sanction loom, decision makers are apt to conclude that routinized sexual assault that we see so often on campus does not merit that extreme sanction. So we have a little bit of a chicken and the egg problem, okay? We're trying to engage in social justice and social change. And when you have people who don't share the same assumptions that we share, that it is inappropriate to take advantage of someone who is extremely intoxicated, that it is inappropriate to press forward when someone says no, that it is inappropriate to force yourself on someone sexually when they have no indication, when there is no indication that they're interested. When we're trying to change those norms, we have to be sensitive to the ways that penalties that are mandatory may inhibit our ability to do the social justice and social change work that we want to do in terms of people's attitudes toward sexual assault on campus. Recommendations for activists trying to create systems which encourage reporting and provide just outcomes to survivors. Yeah, I think we've got to proceed on two separate tracks. One is we have to provide a whole range of options for people who want to report. We've got to have confidential and anonymous options. We've got to have confidential options. Those are slightly different. We've got to have options that are public. We've got to have options that involve the criminal justice system, and we need to support survivors to be able to make decisions and to control the process to the extent that she or he can. And to make decisions between those options. That's going to encourage reporting. I also think that another avenue of potential encouragement for reporting is the option on campuses of restorative justice. Restorative justice is a totally different way of thinking about the potential for penalties, because it can actually dramatically reduce the penalties when someone acknowledges responsibility for wrongdoing, seeks to make amends in a structured fashion that provides adequate support, adequate emotional, psychological support for the victim, and potentially for the offender as well. I think we want to attend to both sides on that. I've said a lot here, and I assume that some of it will be objectionable to some. And I'm looking forward, and I'm totally open to talking about any of this, and look forward to speaking with any of you if you have questions. And so I'll end my segment for now.
Wonderful. Hi, everyone. Thank you so much to Adaku, Alexandra, and Michelle for taking the time to speak to us tonight, sharing your knowledge and helping us understand such an important topic, and for really all of the incredible work that you do. And thank you to everyone who joined us tonight. I'm Rebecca-Crevitt. I am an organizer for Know Your Nine, and I'll be facilitating our Q&A. So we're going to stop recording before the Q&A so we can have a little more privacy. But here's some housekeeping. So for everyone else who were not able to join us today. Going forward, there are many ways that we can continue talking, working, and connecting together after tonight's call. If you're not already part of the 9CAN network, you can sign up online. We'll be sending around a link to sign up, and you can send it around to any of your friends and other activists you know who may want to be a part of our student network, along with the recording. So any student or activist group is welcome to join. If you're organizing for change on your campus, 9CAN will connect you with a lot of resources. For example, we host Title IX boot camps, 2-day regional trainings for students to come together and learn skills, strategize, and build community together. And if you have any questions or thoughts and want to get involved with our next teach-in or any other of Know Your Nine's programs, please reach out to us at knowyour9@gmail.com. That's knowyourix@gmail.com. We'll be in touch with you for our next teach-in, and we really hope that you can join us. Okay, so I'm going to stop recording now. Okay. Having trouble stopping the recording. Oh, here we go.